Welcome to the Society of Labour Lawyers webinar. It's the fourth in our series on justice and COVID-19. My name's Catherine Atkinson. I'm a barrister and secretary of the Society, and we have got four fantastic speakers for you this evening. We have Ellie Reeves MP for Lewisham West and Penge, who is our new Shadow Solicitor General. We have Adam Wagner, human rights barrister at Doughty Street, who set up the UK human rights blog and is founder and chair of the human rights charity Each Other, as well as presenting the Better Human podcast. And we have Lord Willy Bach, a former barrister, previously parliamentary Under Secretary of State in Justice, and since 2016, Police and Crime Commissioner for Leicestershire. And a bit later in the evening, we will also have join us Schona Jolly QC, chair of the Bar Human Rights Committee, as well as a barrister at Cloisters Chambers. And once we've heard from our speakers, as always, we will have questions and contributions from participants across the membership of the Society of Labour Lawyers. And if you can put your hand up if you want to speak, so we can switch your video on, or send me a question if you'd prefer for me to read it out, or a contribution, obviously. So I know that sadly we were going to lose Ellie Reeves partway through this evening, so it would be fantastic if we could start with you, Ellie.
Okay, thanks very much, Catherine, and it's great to be speaking at this webinar of the Society of Labour Lawyers. I was actively involved with the Society for many, many years. I think first when I was at Bar School, I was the administrator for the Society, and then went on to edit the newsletter, which I understand has now turned into a blog. It used to be a sort of paper that we would send out to people every month or so, and I served in the exec for many years, so it's fantastic to be speaking at this webinar. I was very recently appointed Shadow Solicitor General. I have been the Member of Parliament for Lewisham West and Penge for almost 3 years now, and before that I was an employment rights lawyer for many years, mainly representing trade unions and their members, and then before entering Parliament, focusing on discrimination work, particularly in relation to things like maternity rights and family-friendly working, and then elected to Parliament in 2017. Was delighted to be appointed Shadow Solicitor General just a few weeks ago. I'm sorry I have to leave at 6:30. I'm technically supposed to be on maternity leave. I've got a 5-month-old baby. Maternity leave doesn't really work in the middle of a pandemic, but he does need to go to bed at 6:30, so I will have to leave then. But I want to say a little bit about some of the things that I'm thinking about in terms of civil liberties at the moment. And myself and the Shadow Attorney General, Charlie Faulkner, have been speaking at length about some of these issues and trying to sort of bottom out what we do about them. I think at the moment people generally accept that there needs to be curtailments to their civil liberties in order to keep them safe, in order to help the NHS, and in order to save lives. But ultimately, this is an issue that isn't going to go away anytime soon. And when the Coronavirus Act came into force, it was almost sort of like legislation done on the hoof. A lot's then been done in guidance. There's often a disconnect between what the legislation says and what the guidance says, and a lack of clarity. And I think one thing that we're really, really conscious of is that actually there needs to be a proper legal framework for all of this. Otherwise, I think we risk losing confidence of the public in social distancing measures, in the lockdown, in the restrictions that I think we're going to see for quite some time. So having a proper legal framework, it's I don't think it's going to be a satisfactory position if a lot of decisions are made by local officials. And Willy, you might want to say more about this in terms of your experiences as Police and Crime Commissioner. But if you've got a situation where effectively it's left to localised police forces to decide what the guidance actually means and how to interpret it. So, for example, we heard the story of the police officer, I think in the Midlands, that sort of over enthusiastically was checking someone's shopping basket in the supermarket to see whether the things that were in it were counted as essential items. And of course, that wasn't necessary. That wasn't something that he was required to do by law. We're seeing things like, for example, park benches in some local authorities taped up so we can't sit on a park bench, and then we sort of think, well, you know, actually, how then do people that have got disabilities go out for their daily exercise if they can't pause to sit down for 5 or 10 minutes on their walk? And things are done in quite a piecemeal way. It's being left to local authorities, it's being left to police forces to interpret the guidance. And I really do think that we need to be pushing for there being a very, very clear legal framework setting out what the restrictions are, what that actually means, and how decisions should be made. So we don't have this kind of piecemeal approach. Needs to be set out in statute. So that's one of the things that we're looking at and thinking what that might look like. And the other big issue on our radar is this contact tracing app. It was Attorney General questions yesterday in the Commons, and it's one of the questions that I raised in the chamber, albeit virtually, but in the chamber, was supportive of the app. But we want to, in principle, but we want to make absolutely clear that it isn't going to go too far. So, for example, what we want is there to be primary legislation, and I pressed the Solicitor General on this yesterday, primary legislation that sets out the scope in law, in primary legislation, and also to ensure that it's GDPR compliant. And one of the worries that we've got is the implications of Brexit, all of this, because this is going to be going on well beyond the transition period, and GDPR obviously comes from Europe. Will it be GDPR compliant both now and in the future? So I questioned the Solicitor General about this yesterday. Can't say I got a particularly robust reply on either of those points in primary legislation and GDPR, both now and post Brexit. And these are the sorts of things that we need to be pushing on, and making sure that people have confidence in it. Looking at things like decentralisation, how data is stored, how long it's stored for. And who has this data, who has access to it, and for how long. These are going to be, I think, some of the most pressing issues, and it cuts across departments. So, for example, it's not just the law officers and justice team that are concerned about this. Shadow Cabinet Office, DCMS, and Health are all working on this. So we're doing a lot of joined up work on what this app might look like, the importance of it, but also the safeguards. And I think that's going to be something that in the days, weeks and months ahead, we will, as an opposition, be thinking a lot about. Keir Starmer's made it clear that we're not going to have opposition for opposition's sake, but actually these are really, really important and fundamental questions that we need to be probing the government on and holding them to account on and scrutinising them to make sure that they are thinking about these issues and making sure they're thinking about safeguards and how this will all work in practice, rather than a kind of making it up as they go along approach and dealing with the legal fallout and consequences afterwards. I've probably done more than my 5 minutes. I apologise, Catherine. But it's happy to answer any questions. I'd also looking forward to hearing what other panellists have got to say. Thank you.
Fantastic. We will take questions once we've heard from Adam and Willy. But if I can start with Adam, I think you're going to give us a little bit more of a kind of technical briefing on the coronavirus laws as they are.
Yeah, I am. I was just wondering, can I share my screen, or is that not available to me?
I think you should be able to, our administration should be able to help you do that now.
It doesn't matter. I'll just, it's not a problem. Okay, so I want to talk about a couple of things in my 5 minutes, and I should probably set myself a timer. And they are, so I've been working as specialist advisor to the Joint Committee on Human Rights on their COVID-19 inquiry, which is going on at the moment. And if anyone wants to submit evidence to that, it's open now on the inquiry website. Hold on 1 second. I've managed to get rid of this. 1 second. So I just wanted to give a couple of minutes on the two main issues which the Joint Committee has been looking at the outset, although obviously coronavirus and the response to it gives rise to a sort of the full panoply of human rights issues. It really is the most significant human rights issue of our time, I think, certainly since 9/11. And the two issues that I want to talk about, first of all, the lockdown, and just to talk briefly about what the laws are that enforce the lockdown, that allow enforcement of the lockdown. And the second thing was briefly on contact tracing, which Rachel's already mentioned, but it's going to be a big civil liberties issue over the coming months with the launch of the new NHS X app. So I'll just start with the coronavirus legislation. There are two main areas of legislation. There's the Coronavirus Act, which came into force towards the end of March, and the coronavirus, the four different sets of what have been called the lockdown regulations. But there is one set of regulations for each of the constituent parts of the UK. And one of the initial areas of confusion is they're not the same. They're not identical. They're similar but not identical. The regulations themselves in England were brought in under the Public Health Spread of Infectious Diseases Act 1984. And that it's one of the legal questions over the regulations has been whether they are a lawful use of the power under the Public Health Act, and that is a question which may have to be resolved a bit later. But lawyers are kind of split on that question. But the court will probably give the government the benefit of the doubt, but who knows? The regulations that enforce the lockdown, so the ones that you're most likely to have heard of, are the ones that prevent us from gathering in public places with more than 2 people not from our household, and not leaving the house, and more recently, by an amendment, being outside of the place where we live without what's called a reasonable excuse. Those regulations were brought in under emergency powers, so they weren't debated in Parliament, and they haven't been debated in Parliament yet, and they've been enforced now for over a month without any debate in Parliament, which you might think is a significant issue in terms of scrutiny and accountability, and particularly on the basis that they are meant to, under the Public Health Act, only last for 28 days without being affirmed by both houses of Parliament. But because of a bit of I guess a lucky break for the government, or whichever way you want to put it, they were brought in just at the beginning of the Easter recess, which means that the government actually has had almost an extra month without those regulations having to be voted into Parliament. And they were amended on the 22nd of April following a review. Now, the Secretary of State for Health has to review by the regulations themselves. They require him to review them every 21 days to ensure that they're still proportionate and necessary and lawful. And he reviewed them and has, I think yesterday, produced a very short note saying, I've reviewed them, they're not going to be changed substantively, or I guess reduced down, until the government's 5 tests are met. But they made some pretty significant amendments a few days ago, which were again brought in with no debates, and they were brought in effectively by executive fiat, which I think it does give rise to some significant issues. I won't go into the specifics of the regulations, save to say that probably the most controversial element of them, and the most difficult, is the requirement that you can't be outside of the place where you live without a reasonable excuse. Now, there's a non-exhaustive list of reasonable excuses, and I'm sure there'll be questions about, and I think Willy will talk about a bit more about the police using these powers in ways that they shouldn't, searching people, shopping trolleys, setting up roadblocks, going after people for buying Easter eggs, or having picnics. Picnics is probably debatable. But the point is, there's a list of reasonable excuses which is non-exhaustive, but it does mean a lot of discretion is placed on police. And the additional bit of discretion that's placed on police is that the language of the enforcement powers is very subjective to the police. So for example, not just the police, but a relevant person, which can include a local authority officer, can take such action as is necessary to enforce any requirement imposed by the certain of the regulations. And a police officer who considers that a person is outside of the place where they're living, in contravention of Regulation 6, which is the reasonable excuse regulation, can direct them to return to the place where they're living, or remove them if necessary using reasonable force. And just to note there that it considers that a person is outside of the place where they're living. So all that's required is the police officer to consider that that person is outside the place where they're living, not for them to actually be outside the place where they're living. And there's a lot more to say about that. The Coronavirus Act is a bit more limited in terms of the police powers, but it does give the police powers to remove people who are potentially infectious, and that's given rise to some significant issues and already some miscarriages of justice. I'll mention very briefly contact tracing, and I'm sure we can pick it up. The issue with contact tracing isn't just about an app. It's about finding out where somebody who is infectious or potentially infectious has been, and getting in touch with all of the people they've contacted to try and get those people to isolate themselves to prevent the spread of the infectious disease. Now, that can be done in the crudest way, by a public health official interviewing the individual who is potentially infectious or infectious, and finding out where they've been, which is very, very intrusive in terms of privacy. So some countries have been using technology to, in theory, use a less intrusive in terms of privacy version of contact tracing, which effectively works automatically by an app. There's lots of different ways the app can work technically, and this is where the rub comes, and this is where the danger comes. There is a Google Apple API, which is a mechanism whereby the phone can use anonymously, and in theory protecting privacy, can detect when it has been near somebody with a tag, a Bluetooth tag, who has declared themselves to be potentially infectious, and it then tells the user that they've been near that person, because it's constantly checking which Bluetooth tags you're near. The government has now rejected, I think as of yesterday, that idea, and have gone for they're proposing a centralized server with all the attendant risks. Of course, they say it will be very carefully protected, and the centralized data will be only used for necessary purposes, but it does give rise to some potential risk, particularly of hacking, but also just either messing it up through negligence or through a sort of mission creep. So there are really serious issues which are going to be, I guess, debated in the coming days and weeks. And I think that I'm over my time, so sorry about that.
Thank you very much. Willy, we'll come to you now, and we're going to have to start getting a bit strict on time, or else we're going to erode the time for contributions from other members. So Willy, please.
Thanks very much, and good evening. I'm not an expert at all on civil liberties, I'm afraid to say. I used to be a criminal law barrister for many, many, many years, but that was a long, long time ago. Just to say, to begin with, to remind people what the powers of a police and crime commissioner are. Each police force has one, of course, and our prime aim really is to hold chief constables and his or her force to account for the following: efficiency, effectiveness, and perhaps importantly in this respect, legitimacy. The protocol gives police and crime commissioners an interest in what's described as, and this is the word used, the totality of policing. So Leicester, Leicestershire and Rutland make up the force area, Very briefly on that, 1.1 million people, a growing population, very diverse, as I'm sure people know, with the city being politically very left, very Labour, the county being equally conservative, and Rutland, of course, being conservative too. But their diversity in every conceivable way, in race and in faith, of people who live in this area. There are also huge differences in poverty and wealth. You can go 5 miles from a poor part of Leicester into some of the best, nicest villages in England. The police force, middle-ranking police force, not the smallest, not the largest, with a good reputation and a very liberal-minded chief constable, who's still a young man but been there 10 years, got a good reputation, and with a very good chief officer's team. So this legislation, as has already been said, the regulations and guidance, is incredibly severe because COVID-19 is incredibly severe. And this has, as has been said, huge implications for the police. We police by consent in this country. Everyone knows Peel's words about the police are the public and the public are the police. The police are used every day to deal with, are used to dealing every day with the criminal behaviour. Often, of course, to protect other people's freedoms, they have to deal with criminals who put that freedoms at risk. But here, Parliament has removed everyday freedoms, or the government has rather, at a stroke. And the police here are given immediate duty to operate the new law. It's, as has already been said, a huge discretion that's allowed to the police, which involves an unheard of right to interfere in people's lives. As a lawyer, my main concern is that in exercising these new powers, and hopefully they won't have to be with us for very, very long, the police respond, sensibly, obviously proportionately, and with good common sense. Are they doing that in Leicestershire? Well, I can say from what I see, and I talk to the chief a lot, I go to the police gold groups where the details are discussed, that they're following the engage, explain, encourage, enforce 4 E's system. I believe they are doing that as well. And the numbers of fixed penalty notices, which is the way in which they deal with breaches of this kind of legislation, when last looked at across England and Wales, they looked at all the police forces, was somewhere right in the middle. And today's figure is around 300 fixed penalty notices over 5 weeks for breaches of this legislation. And it may be of interest that about 70%, a bit less, were to do with breaches as far as restriction of movement was concerned. Some 25% was around meetings, gatherings of more than 2 people, and about 10% with just failure to comply with breaches of this legislation. That's interesting that of all those notices, 55 of them came from 19 incidents. So sometimes incidents are rather larger than you might think. Doesn't look like disproportionate use by police officers at the present time, given their immense powers. And I know quite a lot of trouble is taken to ensure that every arrest is, every notice is properly given. Of course, there will be mistakes made, and I'm sure they have. But I'm pleased to say at the moment, we've not been responsible in any way for sort of absurd comments around checking, shopping, etc., etc. And I'm very keen that it should stay that way and take a big interest in it. It's got to distinguish between those offences that arise, they're called offences, from the recent legislation, and of course COVID offences, where the police are assaulted or spat at, or where defendants behave in a similar way in a shop or to other people. And the figure for that is about 120 over the last 5 or 6 weeks. I think all this gives the police a very, very difficult job to do. I don't think I've been won over naively. Having looked at it pretty closely, my feeling is that here we're doing it okay. I suspect that's true up and down the country. But this kind of huge power that's really given to the police is not something I think that the enlightened, and a lot of police chiefs are enlightened these days, that enlightened police officers really want. It's not a way that I think they want to police, and obviously the sooner it can go, the better. So I hope I've given you just a brief taste of how it is on the ground in one part of Middle England. And of course, I'm happy to answer questions in due course too.
Thank you. We have got a couple of questions, and I'm conscious that Ellie needs to leave in the next few minutes. So I want to quickly just ask these two questions, and then for closing comments from Ellie, if you can squeeze in a couple of minutes to speak to us one more time before going to our other speakers. So the Coronavirus Act prevents people from what would otherwise be lawful assembly. Journalists are operating under considerable constraint. In those circumstances, how can the government be held properly to account in a situation where it could well be argued the government has let the country down quite appallingly, with the second highest deaths per capita in the G7, inadequate testing, failure to supply PPE, NHS underfunding, etc. We also have a question from Omar Salem, who will be coming up shortly. And we have a question from Thomas. That first question was from Adrian Williamson QC. We'll have Omar Salem shortly, and we've got one from Thomas Webb about local authority disinfecting and whether there's likely to be any protocol issued about getting that disinfection. Do we have Omar? Well, Omar, are you there?
Hi.
Do you want to ask your quick question before we hear from Ellie before she leaves?
Hi, hello. It was more kind of a contribution, but I think you would have seen, hopefully, all that we've just society's obviously just published a paper on some of the legal issues relating to easing the lockdown, and there are kind of a couple of things that I just wanted to highlight as for comment. Firstly, is the importance of using a decentralized approach for any tracking app over a centralized approach. And the second is, which I don't think we've really bottomed out yet, but is, I think, an important one, is whether GDPR alone is an adequate data standard, or whether people should be able to have a higher standard than the GDPR normally allows. I'd be interested if that's, especially from Adam, whether that's something that has been being considered by the Joint Committee at all.
Thank you very much. So, Elliot, a wide range of things to finish on. So, looking at accountability, disinfection, and the centralised versus decentralised, and is GDPR a high enough standard?
Fine, okay. Just very briefly, because I've really got to dash, but in relation to accountability, I think it's a really, really important point. And, you know, at one point we weren't quite sure even what was going to happen with Parliament and whether there'd be an opportunity to hold the government to account in Parliament. It's taken quite some effort to get Parliament to sit virtually. Parliament isn't known for being particularly modern in its working practices, and the fact that we are actually having questions every day and PMQs and so on does make a difference, although it's not the same as everyone being in the chamber. I do think that is an important thing in order to press the government. You're absolutely right. There has been some shocking failures on testing, PPE, etc. And I think it is really, really, really important that we get that opportunity to hold the government to account. In relation to the paper that the society has put together absolutely excellent and really, really helpful to me. I've read it and it has informed a lot of my thinking and will do so going forward. So just to say very many thanks for that. It's been incredibly helpful, and the input of the society is very, very valued and very, very worthwhile. So just thanks for that. I have to dash, but thank you. It's been a pleasure to join you,
really
and hope to join you again soon. Bye.
Thank you, Ellie. The paper that was just raised was the legal consideration for easing the COVID-19 pandemic lockdown restrictions that the Society published yesterday, and there will be an extra webinar with Lord Faulkner next week. So more details about that at the end of this seminar. It's fantastic that we have got Schona Jolly QC, who has joined us this evening, and I promise that the questions that were asked will not be forgotten, but it would be fantastic to go to Schona first, and then I will recap the questions before coming back to our speakers. So Schona, if to jump on you as you've now arrived, it's can we hear from you now?
Yes, of course. Evening, everyone, and I'm sorry that I'm late to this meeting. I had another commitment I had to meet. I don't know what has been covered so far, but I think you've probably been talking about police enforcement of the coronavirus regulations and possibly tracing and privacy. I didn't have a specific brief for what to talk to you about this evening, so I wanted to focus on a couple of things that I've been focusing on a lot that have been coming to me over the last 2 or 3 or 4 weeks, and that is the question of PPE and how that fits into the civil liberties and human rights framework at the moment. It concerns a range of human rights and a range of legislation across different fields, including labour law. It's affecting very significant parts of the workforce, and not only doctors and nurses, but people in care homes, people in all kinds of key work positions. And I just want to give you a flavour of the discussion, a flavour of the rights concerned, and some areas to flag, so that these can be things that we think about either in questions or perhaps after today, and to think about an approach to those. So when you think about PPE, I think there are 2 or 3 key convention rights that come into play. The first is Article 2, which most of you will know is the right to life. And the right to life involves both positive and negative duties for the state. And there are a range of positive duties that are engaged or likely to be engaged that involve the discussions on PPE, and I won't set that out in any detail. I think you're all familiar with the very wide debate in the public eye about the failings on PPE. The positive duties on the state include various different measures that include adequate systems in law to protect or to safeguard life. There needs to be a legal framework that provides effective protection where the duties are engaged. There may be, or there is, a duty to provide information to individuals whose lives may be at risk. And there's also something known as the Osman duty, which is a requirement on the state to take operational steps to safeguard individuals against real and immediate risks to life. Now, the reality of all of those is that they are subject to the lens of discretion or margin of appreciation. And what that means is the duty that emerges is to some degree restrictive. But I think that many, if not all, of these duties are likely to be engaged by the current scenario. And there are likely to be real questions, if not now, then when the immediate crisis comes to an end, in respect of the provision of PPE and the framework surrounding it and the information and the provision of PPE itself. It's worth saying that just a sort of mere negligence claim won't necessarily trigger Article 2, but you have to look at it in this wider context. And you may have seen the coroner's guidance that's out in relation to the way in which inquests might take place that concern Article 2. There are discussions to be had about whether inquests are the best form for these sorts of inquiries, whether a public inquiry is a better form, and or whether there are individual rights pursuant to the Human Rights Act and Article 2 that individuals might take. So that's one aspect of PPE that is important and broad. Another area that I wanted to pick up on is Article 10, freedom of expression rights. And a lot of you will have heard about the gagging clauses that are apparently in force in various places. The Guardian has reported it, other newspapers, I think the FT has reported it. It's certainly been broadly reported that there are members of staff in the public sector who are being gagged from speaking about the lack of PPE. Now, there is actually the right to freedom of expression to express what's happening does apply in the workplace, in the public sector. It's very important to look at those rights in the light of the whistleblowing framework that appears within the Employment Rights Act and within labour law more generally. They operate in the way that Article 10 operates and has been interpreted by the European Court in Strasbourg. Many of the measures and questions are quite similar when one looks at the question of proportionality. But Article 10 is an important recourse, not just for the nature of the debate itself, but also for those people who don't qualify for protection. So there may be people who don't qualify either as workers, for example, volunteers, may not qualify, job applicants outside of the NHS may not qualify. So Article 10 provides a broader protection and for others who may want to come forward. There are Article 8 rights engaged to the right to dignity, the right to your working life, the right to your family. But a lot of those will be covered through the broad plethora of health and safety legislation, employment legislation, etc. I think a really important right that we have to think about in the context of PPE and more broadly in the context of the impact of COVID is Article 14, which is the non-discrimination right. We have to think about the way in which it might be engaged in respect of BME, deaths and impact, and potentially on the question of production or provision of PPE as well. So these are just a handful of the issues which are engaged by the single topic of PPE. And there are broad other questions which come about engaging Human Rights Act and engaging our discrimination legislation, our employment legislation, and more broadly. There are lots of things that I could talk about in the same vein. We could talk about the do not resuscitate orders and the recent guidance from the BMA, and we can talk about similar provisions affecting the rights of disabled people in the community, etc. The one other point that I just wanted to talk about very briefly and to flag, and then I'll stop there, is thinking about the engagement of Article 5 through the coronavirus regulations, and I don't know to what extent Adam's already covered it, so you've talked about this, which is the provision relating to the deprivation of liberty. And there's an awful lot of legal analysis on this and the coronavirus regulations. But what I wanted to flag at this point, I think a lot of these things are useful to think about as the coming weeks approach, is not just Article 5 in terms of the immediate questions about deprivation of liberty, but the potentially discriminatory implications as well. So you see Article 5 hand in hand with Article 14, potentially even Article 3. And one of the reasons I'm raising this now is because there is widespread discussion that in whatever way the lockdown ends in the next few weeks, it may be a much, much longer period for people of a particular age cohort or people of particular vulnerabilities. And so when we think about the question of a lockdown potentially carrying on for many, many months, even over a year for people over 70, irrespective of their own circumstances as a single cohort, I think we also need to think about the discriminatory implications of the way in which that lockdown under Article 5 and more broadly Article 8, the right to dignity, etc., would or could be justified. And the reality is that the longer this goes on, the more significant the questions of proportionality, the more significant the questions of non-discrimination will be for older people, for people who are disabled in the community but living independently, etc. So there are a range of issues that cover a number of grounds, and I just wanted to give you a flavour of the sorts of things that I've been approached about and I've been thinking about in the last few weeks. You're muted, Catherine.
Thank you very much. That was fantastic, and a wide range of things for us to be thinking about. But before you joined, there were 3 questions that we had that had been asked, and I do want to give the opportunity for all of our speakers to comment on them. And I was going to throw one more in that you may have seen on the webinar chat. So the first was about accountability and how the government can be held to account while we're prevented from lawful assembly. There was also one in relation to disinfection, and whether any of you are aware of any protocol directing local authorities to disinfect public areas. And the question and contribution from Omar, looking at whether or not a higher standard other than GDPR is required. Can I, the new one that I did want to throw into the mix before hearing from each of you was one from Michael Isles, who was specifically wanting to target the question to Adam, but I do think it's one for Schona as well. He was particularly curious about the role on the Human Rights Act and the ECHR, appreciating that some of the rights are limited or qualified, but that the many issues, and we're starting to get into that in relation to Article 5, 8 and 11, and his particular understanding that someone who wishes to challenge a fixed penalty can only do so at risk of a criminal record via a magistrate's court. His question is specifically or simply whether the ECHR or the Human Rights Act is actually being applied, and whether we can expect any challenges to draconian legislation on those grounds. So Adam, can I start with you, please? You've got a range of questions there.
Yeah, and can I just ask if you can remind me what time we're finishing?
Well, soon after 7. So I think that we're going to try and speed through. We might give it a little bit of extra time, considering that we had 4 speakers and we still have more questions.
I'll try and be quick. I just want to start with Omar, who asked about the contact tracing app. I currently I'm in the midst of thinking about this, and I don't have an answer as to which system I think is the best one. And I think that the reason for that is the whole point of the contact tracing app is it's got to work. And for it to work, it has to technically work. So there has to be, the technology must be effective and not give rise to too many false positives or missed bumps with the Bluetooth or however it works. And I know I was listening to Bill Gates saying that he doesn't think that the decentralized version would work because there would be too many false positives. And that's one point. And I'm technically not able to say whether one thing is better than the other. But I think there's a real element of having to listen to the experts and reach the very complex conclusion as to which works best. And I think then you get to the point of encouraging people to sign up to it. And I've read that I think over 60% of the population have to use this app for it to successfully suppress the virus, whilst there aren't other lockdown restrictions in place. And that's an enormous amount. I mean, that's, tens of millions of people have to trust this app. And that means you're going to have to communicate in a particular way. One of the reasons I think whether GDPR, I think GDPR might in itself be sufficient in terms of the principles are very broad and they're pretty strict to regulate this app, but you might want primary legislation as well in order to really hammer home exactly how the government and Parliament interprets those principles in the context of this app. And also as a kind of bit of public communication to say, these are the rules for the app. The data will only be used for 3 purposes, 1, 2, 3, and this is how we're going to restrict it. This is who has control over it. This is where it will be. And I know that for some reason, NHSX has now rejected the Apple Google completely decentralized app, and there may be good reason for that technically, but they're going to have to be very carefully, that's going to be have to be very carefully considered. But I think with all those things in mind, quite obviously this is a huge privacy invasion, this app tracking wherever you go and who you come into contact with, potentially putting that on a centralized server. But on the other hand, being stuck in our houses without being able to go out is a huge the civil liberties intrusion as well. And also ordinary sort of physical contact tracing with a public health official inquiring who have you been with for the last 2 weeks, where have you been, and potentially going into your private life. It's very intrusive as well. So we've got a series of bad options potentially. The question is going to be, what is the least bad option for getting us out of our houses and back into some version of normal life? And just quickly to answer the question from, I've lost it now, but the question about whether the Human Rights Act is being used. Well, I mean, I'm privy to, and I'm sure Schona is as well, lots of lawyers who are going about their business using the Human Rights Act in lots of different ways. At the moment, a lot in the pre-action stage of, for example, in prisons, there's lots of stuff going on through the Howard League, through inquests, Article 2 investigations. There's a huge amount of discussions going on between lawyers and involving relevant organisations. I'm involved in a claim with the Good Law Project using the human right to education for the provision of sufficient equipment to allow disadvantaged peoples to access education. There is loads and loads and loads of stuff going on, but I don't know, publicly, I think there is also an element of some of these issues are so large that it's almost, people are probably a bit worried to say that it's a breach of human rights to lock everybody in their houses, because on the other hand, it's a breach of human rights to allow people to in their tens of thousands to die because your policy's wrong. So I just think that there's a lot going on in the background. There's also an element of the public debate being slightly, I guess, cautious in terms of overplaying the human rights hand. Shona, I don't know whether you agree with me on that or not.
I guess the short answer to Michael Isles is yes, we can expect challenges.
Oh yeah, I mean, there's going to be plenty. There already, lawyers are starting their engines. Have already started their engines for sure.
Absolutely, Schona.
I'll just add to that and agree with Adam. I think there is a real sense that we're still somewhere near the beginning of this crisis, and I think there has, that has a lot of implications. First of all, people don't really know or understand necessarily what their rights are. That's got to be set against a scenario where I think everyone or most people would agree that clearly government is in an impossible situation of trying to save lives, and that's it has an obligation and responsibility to do that under human rights law and more broadly, as well as trying to find a balance for all the various different issues and reacting very, very quickly. Now, some of this is set against a measure of people saying, okay, well, let's wait and see, and guidance is suddenly being produced and evolving and changing, and things are changing very quickly. But also, I mean, as Adam, I mean, we are being approached, and I think there are lots and lots of potential challenges in the offing. But with many of the rights engaged, there are proportionality considerations. And one of the realities at the moment is that we don't know. Nobody knows very much at all. So in some senses, we're too early to be able to necessarily say that things are disproportionate or unnecessary. We just don't know. What's really important is that there is proper scrutiny of the measures. And I think that is a real issue. And I know this week, I'm not a family lawyer, but I know that there were changes made in respect of children through various sets of regulations that have taken place, apparently without consultation, for example, of the Family Law Bar Association or others. And there has been a real concern. This is not my area, so I stress that I don't know the answer to this, but I understand from practitioners in this area, there has been a concern that legislation is being brought in without proper scrutiny through effectively the rushed measures. So I think scrutiny is absolutely key. I wanted to just say there was one question about journalists. Someone, I can't quite find it now, but I saw a question in the Q&A about journalists and whether or not, how this was impacting on journalists' right and freedom of expression. you might be interested in a Council of Europe piece of guidance on the pandemic for all governments dealing with the pandemic, and they have stressed the importance of journalism within this, just as they have stressed the importance that whistleblowers, for example, aren't silenced, and that the media is a form which can be useful for whistleblowers. But that same piece of guidance also recognises that in times of emergency, the press has particular responsibility. And so there is this challenge about misinformation also being out there, which is another sort of measure of the balance. So I think all of these matters need to be scrutinised. I think lawyers and civil society more broadly need to be considering all of this. But we need a moment's pause as we're doing it to reflect and consider the various proportionality considerations, etc.
Thank you. I'm going to move on to Willy for contribution, and then I'm going to try and squeeze in 2 quick questions and then any closing comments. But Willy, in relation to the discussion we've had before, so far I think no one has had an answer in relation to disinfection. So I'm sorry to not get an answer there.
I don't know what the answer is to that. Let's be frank about it. And the other questions are very much for experts in human rights, civil liberties, and I'm wasting people's time if I go on about them. I would just say, because I think you know, Catherine, I have a considerable interest in sort of the whole legal aid issue around civil legal aid in particular. I just hope that if and when these matters are litigated or come near that the legal aid system, or what's left of it, can provide sufficient here, and if not, that should certainly be a battle on its own.
Thank you. I think we had a question from Andrew Dismore, who, if he does still have a question, I will ask for his video to be brought up. But we have one from Sally Hughes, who, which you may be able to read. Quite a lot of what's being said about contact tracing apps is special to using that technology. These questions seem to me to apply more to tech-savvy young people. How do the principles stack up against, 1, factors special to using the app that is voluntary, for instance, and 2, physical/verbal contact tracing, which is self-reported, but which nevertheless impinges on others who are not volunteers in the process? So a bit more looking at the principal point. And we do have Andrew. Andrew, can you hear? What was your contribution? I can see Andrew, but I'm not sure whether he still has a contribution. So I think we are back to looking at contact tracing and looking at it more broadly than just the tracking apps. Adam, can I start with you on that?
Yeah, I mean, obviously the voluntary nature of the app is extremely important, and the GDPR focuses on informed consent. It's one of the big advances of GDPR is this real focus on properly explained consent, where nothing is automatic. There's no ticks in the boxes automatically placed there. You have to explain in plain English what this means, what is going to happen to your data, who is going to have it, who will have access to it, what happens if that access changes, how do I pull out of this, and how do I get my data removed. So I think that will be absolutely crucial, and that's pure public communication, and some in the app itself being able to take people through informed consent. And I think with this app it'll be crucial. The physical or verbal contact tracing, self-reported, that impinges on others who are not volunteers in the process. Of course, I mean, I just think any kind of app that's being proposed is probably less intrusive than a public health official taking you through all your contacts, taking their telephone numbers down, and then calling them up. It really is a lot better than that. Although you could use a combination of the two as well, which I think is what's happening in certain countries like South Korea, China, Israel, where they've used, I think, in all 3 examples, more intrusive versions of this kind of technology.
We've just squeezing it in. We've had a question from Kate O'Rourke just asking about whether or not there's any issue with discrimination for people unable to access smartphones if tracking and tracing is introduced. Schona, can I just more broadly ask you about tracking, whether it be the app or any other means that we might be looking at going forward? I think you're on mute still, Schona.
Sorry. Can you hear me now?
Yes.
Okay. I think the use of all technology has to always come with a fairly substantial health warning from a discrimination perspective. And one of the things that we have seen already in the first few weeks of this crisis is the dramatically disproportionate effect on BME communities. We don't know why yet, but there are some indicators as to perhaps why, but we don't exactly know why. Similarly, I've raised questions about older people, more vulnerable people in society. The use of the app will inevitably impact on those people, and there are likely to need to be all kinds of adjustments made to ensure that the app is accessible and usable and in a non-discriminatory way by those communities. So there's still quite a lot of work to go. I mean, this is of course all set against the reality that we haven't yet had the tech discrimination debate in this country. So we're suddenly we sort of have this double whammy where we're about to be faced with this potentially huge rollout of a tracing app. And we haven't really had a proper discussion about the use of technology, algorithms, etc., from a discrimination perspective. So there are a lot of questions to come, but I think we're still in quite early days at the moment.
Okay, I've got Andrew Dismore's hands back up and I don't want to get in trouble with him, so I'm going to let him ask his question if he has one before closing comments. But Andrew, this is going to be your last shot. I think we might just have a button being pushed without due intent. So if I can just ask, it's been hugely wide ranging, and I think we've only barely scraped the surface on really interesting points, including into looking at future forums, be it inquests or inquiries, and looking at gagging and what might need to happen in the future. And there was a particular concern in relation to challenging penalty notices that was raised. But can I just ask for closing comments? I'm going to ask just for closing comments from Willy, and then Adam, and then Schona.
Well, thank you, Catherine, very much, and thank you everyone who's taken part. I have to say, I think the police's role here is one that they don't want, and one I think they'd be happily rid of as soon as they can get shot of it. I think it's a really difficult role for them to fulfill, and I think it's important that they keep a very strong watch on themselves, and I think police and crime commissioners and others can do that too. I think the police have changed a huge amount in the last 20, 30 years. I think we'd all agree that. I think police with the powers that they're given now, 20, 30 years ago, would have been something quite different from what's happening on the ground in most places now. But it's been fascinating to hear the experts' view on this. And I think that's all I've really got to say, Catherine. Thank you.
Thank you very much, Willy. Adam.
I just want to finish by answering Adrian Williamson's question, because I think that's where I wanted to sum up anyway. I entirely agree. In terms of scrutiny, this is a very, very difficult time. It's almost unimaginable that you would have a public health crisis which prevents Parliament sitting at all and then sitting properly, and at the same time prevents journalists being able to go out effectively on the beat and interview people and get to the bottom of things. Although both of those institutions of the state, if put it like that, have been operating, admirably in some senses. But I think the scrutiny point is becoming more and more important. And I think in the early days of the crisis, and as Schona says, we are still in the early days, but I guess we're kind of at the end of the beginning, to use Boris Johnson via Churchill, I think is right. We're at the end of the beginning, and it's now, you know, the leeway that we've rightly been giving government to allow them to, you know, to bring in emergency regulations pretty much on the nod or without any scrutiny at all, to do what they need to do, and which I think is fair, actually. And I'm not, you know, I'm not saying that government have failed in every possible way. I think that's sort of, it's not the right approach. That leeway is now diminishing, and there has to be a period of reflection, which involves proper data as to what's going on, how are the police enforcing regulations, how many people are dying everywhere, you know, what's happened with PPE, all of this. We have to have robust, real scrutiny, including proper data, so we can get to the bottom of what's happened. And at the same time, you know, parliamentary committees, the newspapers, and eventually inquests and inquiries are going to play an extremely important role in, first of all, allowing us in real time to recognize policy failings or policy improvements and to be able to apply them. Secondly, to be able to properly scrutinize and change the legislation in order to make sure that it only goes as far as is necessary and proportionate. That requires scrutiny. You can't do that without scrutiny, because there has to be a feedback loop between the or a mechanism of feedback between what's going on the ground and public authorities, so they can properly deal with that. And I think finally that there should be some thorough investigations which have specific purposes, whether it's looking at PPE, whether it's looking at how the police have behaved, whether it's looking at government decision making. But I think that will come a little bit later. At the moment, we're in the sort of we're in the middle stage of this sort of real-time scrutiny being necessary, and that will require creative and quite thorough approaches by all the different bodies that usually do the scrutinizing, including the law as well, which I haven't mentioned the courts, but the courts will have to play a role. I haven't even mentioned the fact the courts aren't open fully, which is just another, you know, the inquests aren't happening. The jury inquests can't happen at the moment. All of my inquests have been put off until the autumn. So these mechanisms are not there. We have to mitigate it somehow, and we're all going to have to sort of work together to do that.
Really, really interesting. We had a webinar particularly on the impact on courts, but we really didn't focus on the impact on inquests. So that's certainly something for further consideration. Shona.
Well, I feel a bit of a fraud actually to come in with closing comments when I only came in with opening comments a little while ago. But I think there are 4 key words that I would kind of like to throw out there as informing the human rights debate when we think about the response to the crisis. The first is transparency. You will never be able to measure the proportionality or the necessity of any measure until there is transparency around the steps being taken. And I agree with Adam that we are now at the stage where there needs to be a real shift to understanding data, to releasing data, and to government being, I think, I too, I'm not criticising government at every step that they've taken, but I think it's important that in order to make sure that people's rights are properly protected, we understand the steps government is taking against the data which they are using and are sufficiently transparent about doing that. I think that's very important. Secondly is accountability, and it's the sort of, you know, the other side of the same coin, but I think we need to see decision makers owning their decisions and being able to explain why they've reached them, and we can't have a sort of defensive approach to this. If we are truly all in it together, which is a phrase that's been used a lot, and we know that some people are truly in it much more than other people, that's the reality of the situation that we are in, there needs to be a sense that we're all being told the truth. There needs to be a sense that people are owning the decisions, and there needs to be a sense that they're owning the decisions because there is informed processes and informed decision making going on behind the scenes. So I think accountability is also extremely important, and it can't be just that we have accountability at the end. It isn't good enough to say that we can put all of this, all scrutiny, all transparency, all of this can be kept on one side until afterwards, when we'll have a public inquiry in 5 years. That's not good enough. We need to know these things now. And part of the purpose that you see with, for example, some of the judicial reviews that are being launched, some of the threats of legal challenges that we are seeing, is not because people are trying to have a go at government. It's because people are trying to get clarity in the guidance or clarity in the law, so that the steps can be taken now to save lives now, rather than worry about what went wrong when it's too late, although we will need to do that too. The third buzzword or keyword that I would like to keep in focus is the word proportionality. And I think both Adam and I have reflected that there has been this period in which an awful lot of leeway has been given to our government and to governments around the world who are acting quickly in respect of a threat faced. But we are now beginning to approach the period where actually that leeway can't carry on forever, and we need to understand what's happening. So again, proportionality feeds into the question of accountability and transparency. Is what's being done, and is what's going to be done in respect to future measures going to be proportionate? And for that, we need to have data, transparency and accountability. And finally, the word that you don't often hear at the moment, but it's dignity. And dignity, I think, is in many ways lies at the heart of the human rights debate. And wherever we are now and wherever we move to next, I think we have to remember that we're not ever just dealing with figures and with stats when we're talking about the deaths and the impact. We are talking about people, each of whom has rights pursuant to our legal, domestic and international framework. And I think if we keep that in mind, when we think about issues, for example, the way the lockdown will affect a particular cohort of our society, we bear in mind their right to dignity, which in many ways is the underlying premise for so many of the rights that we take for granted within our framework, then we are taking a step in the right direction. So I think that's a really important framing.
Thank you very much. We've been incredibly lucky to have four fantastic expert speakers, and it's hard to get you a round of applause when you're on a Zoom call, but very, very, very heartfelt thanks to who we no longer have, Ellie Reeves, the Shadow Solicitor General, to Adam Wagner, to Schona Jolly QC, and to Lord Willy Bach. Next week, we have not one but two webinars, because we do have an extra webinar that was mentioned earlier on Tuesday at 6 p.m. That is going to be looking at the paper that the Society of Labour Lawyers has published, the legal consideration for easing COVID-19 pandemic lockdown restrictions. That will be with Lord Faulkner, our Shadow Attorney General, and with contributors to that paper, Ellen Griffiths and Axel Landin. The following day, on Wednesday, we have our next in the COVID-19 and justice series of webinars on housing law. And that will be with Thangam Debonair, our Shadow Secretary of State for Housing, with Liz Davies, barrister at Garden Court, housing specialist, and Tom Zagoria from the Labour Homelessness Campaign. So again, a really interesting topic for you next week, and we hope that we will see you then. Thank you.